Okay, we got a couple of announcements. One is I put the midterms, the last two midterms in the Wolfram, and then you had exams number one, and I had put in that folder, I had put the two from last time. So I put the exam number two, so in that folder then you can look at what the exams were in 2019 and 2017. Okay, so take a look at those. I may put some more sample questions in that sample questions folder as well. So just again, you can just sort of judge how well you're understanding the material by just looking at some of those questions. They may not be exactly the ones that'll show up on the midterm, but it'll give you, if you can't figure out the answer, it probably tells you that you didn't quite get it. Maybe you should look at your notes or go back and look at the book or something. The review session is going to be on Thursday. Did I announce that already? Okay, so it's going to be on Thursday, and we're going to do it from 8 to 9, and it'll be in this room. So I've got this room for the Thursday before the exam. Okay. I forgot to do band pick for you guys on Monday, and it's Sam Fender. Anybody heard of Sam Fender? Okay, it's an indie rock. He's an indie rock artist. He started in 2018, and he's British, UK, and he's probably the song you might want to listen to just to get an idea of him is The Borders. So you might just take a listen to Sam Fender. All right. So what we're going to do now is look at topics again in contract law. So just again, like we've been doing, where we've laid out sort of the basic analysis, economic analysis, and then look at some commentary on some of the things that might cause problems or in a little more detail. So if we think about contract law, what do we want to do? We want to have enforcement, right? So why? Is because contract law is about bargaining, right? That is, tort law was about accidents, didn't have time to bargain for something. But contract law is we're going to make a bargain, and bargaining improves the position of both parties, right? There's a cooperative surplus from bargaining. And so what we'd like to do is we'd like to have enforcement so that people will think, yeah, I should be able to bargain, right? If you don't think the bargain's enforceable, you're less likely to come to an agreement. So what we're going to look at here is we'd really like to have enforcement is we want to have it so that people will reach a bargain, and in particular, we'd like to have optimal performance. And what do we mean by that? And we'll go into a little more detail, but optimal performance is just like in tort law. What did we want to do? We wanted everybody to take efficient precaution, right? We wanted to set the marginal social costs of additional precaution equal to the marginal social benefit, which is the reduction in the expected value of the loss. Okay? So you got a similar idea here. What we'd like to do is we'd like to have the promisor, the promisor take precaution against breach, but we don't want the promisee to over rely. Right? We don't want them to go out and if they can be compensated for their reliance, then they'll have an incentive to rely more than what is efficient. So what we're going to do now is take a look at remedies for the failure of the promisor to deliver. All right, so take a look at some remedies. All right, when the promisor fails to deliver. Well, we can think of the types of remedies. One is they could be built into the contract, right? The parties will designate, right? It's in the contract. it's okay, if you fail to do this, then here's what's going to happen. The court could impose damages. Right? Or third, the court could specify specific performance. Right? So you go to court. We'll look at these in a little more detail here. But so basically, you know, what could happen is the contract would say, here's what happens if you fail to deliver. Okay? The other thing is that the court could say, okay, the promisor has to pay damages to the promisee, or the court could say, promisor, hey, you've got to perform, right? And again, you sort of think it through. We'll come into this in a little more detail, but you know, in contract law, it's again similar to the tort law in that you could, or even the property law. Remember we talked about property law? You could cross somebody's property and then pay them. You know, so you got sort of the same idea here, that you know you wanted to assign the property right to the. And if you assigned it to the person that it didn't value it enough or didn't value it as much, the other party could go ahead and you could have a forced sale in a sense, so that they could undertake the trespass on your property and then compensate you for doing it. So you got a sort of a similar story here. So let's talk a little bit about each of these types of remedies. One is if the parties could put into the contract, if you think about this one, let's say you say, okay, it's written in the contract that if you fail to produce what you told me you were going to, there's a $50 a day fine, right? There'll be something in the contract that says what happens, right, if you fail to deliver. Could be some sort of, you're going to pay, let's say, just as an example, pay $50 a day until you perform, right? Or it might say that you have to go to arbitration, right? There might be something in the contract says if you fail to do this thing, you might have mandatory arbitration. Sometimes that's. Well, what's one of the problems here is that you got a cost of writing the contract, right? There's an administrative cost. You got to think through, oh, gee, here's all the things that could happen. Here's what we're going to agree to, right? Because you're writing the contract. Here's what we're going to agree to as the penalty for not the promisor not delivering, right? So that is costly from an administrative standpoint. So normally, right, not every failure can be put in the contract, right? Because it would be costly to think about all that, right? It's too costly to basically think out all the options that could happen and all the things that you might want to do to be the remedy for the failure. So most contracts don't specify remedies for all the things that might happen, right? It might have the simple contracts might, and maybe we talked about you might have contracts where you just agree with one another. And so, like we said, with the handshake or something like that, okay, like it doesn't, if you don't do this, we're going to, you give me $10 a day until you get it done, right? But in general, the courts will deal with the particular remedy. So let's look at let's now look at damages, right? So this was if it was written into the court, into the contract, let's look at damages, right? So the court's going to impose damages. You fail, as the promisor, you fail to deliver to me what you said you were going to do. Well, there's all sorts of different types of damages, right? One type of the first type of damage is expectation damages. And what expectation damages are is that the person that is seeking the damage, right, the person that was victimized, and you know, put it in the tort law language, the person that was victimized gets put into the place where they would be if the contract had been fulfilled. So you put the victim, right, which will generally be the promisee, in the position they would have been if the contract had been fulfilled. Notice this is, you know, looks like in tort law where you have perfect compensation, right? You have perfect compensation for the accident. So the person that was in the accident is in some sense indifferent between having been in the accident or not having been in the accident, right? You put them back to where they would have been on this, you know, put them back on the same indifference curve if they were the injured party. They get put back on the same indifference curve if you have perfect compensation. So you get a similar thing here and says, okay, I'm the promisee, you're the promisor, you failed to deliver. What are the damages of failing to deliver? The damages are, put me in the position that I would have been had you fulfilled the contract, right? So that's what expectation damages are. And so if you sort of think about it, basically the victim of the breach is indifferent between the breach and fulfillment. Just sort of thinking about it that way. The victim of the breach is indifferent to breach or fulfillment. Again, similar in tort law to sticking them, you know, paying them damages that puts them back on the indifference curve that they would have started out with. Now, what we've already looked at is when you have a breach, then when you're compensating people for a breach, when do you want breach to be efficient, right? We want breach to be efficient. We want both parties, just like in the efficiency in tort law, we want both parties sort of think through what is what's the efficient precaution that I ought to be taking for a breach. That is, if I can undertake costs that have precaution against me fulfilling the breach, but it's costly, right? So I got to think through what's the marginal benefit of undertaking the precaution against breach and marginal benefit of taking precaution against breach. And what's going to happen if you pay expectation damages, you're going to, if you pay expectation damages, or pay any kind of damages in general, but if you pay expectation damages, that's going to affect both parties' precaution. Right? Now and we'll look at the different kinds of damages here as we move along, but if you, just as a note, civil law calls these positive damages, right? So if you read something about positive damages, that's what they're talking about, is expectation damages in general. A second way of doing it would be reliance damages. Right? So we could have precaution, expectation damages. 2, you could have reliance damages. And what reliance damages are, they put the victim back to where they would have been had no contract happened, right? So they're going to put them back to where you were without the contract. The victim of the breach is restored to what would have been without the contract. So let's say you rented an arena and in anticipation of this concert, right? So you rented the arena and my band doesn't show up, okay? So I breached the contract. What would, under perfect expectation damages, what would happen? You'd get rewarded based on how much you would have gotten from the concert going on, right? Whatever profit you would have got from whatever the concert went on. So you're indifferent between my band showing up and my band not showing up. You're either going to get the profits that you would have made in the concert, or you're going to get what I'm paying you in damages. Under this one, under reliance, you're just going to get restored to where you were had no contract happened. That is, you would get paid, I would have to pay you for the rental of the arena or whatever expenditures that you made, relying on my fulfilling the contract, right? That's why it's called reliance damages. I relied on you fulfilling the contract, and so I undertook these expenditures, and I get restored to where I was before, and so I'm happy. I'm indifferent between not having had the contract at all and you paying me the reliance damages. A third way of doing it would be opportunity cost damages. And what opportunity cost damages are is that you have a second opportunity. What did you give up when you undertook the contract with me? Okay? That is the value of the next best option. That is, suppose that you were going to sell me your house, but then you renege, right? You don't sell them to me. I could have bought another house, which now I can't buy because it's not there any longer, right? So obviously the other house wasn't as valuable to me as your house. Otherwise, I would have bought the other house, right? So the opportunity cost damages are you gave up an opportunity in order to when you entered into this contract with me. And so what will happen is if I violated the contract, you'll get the value of what you just gave up. You could think a job opportunity might be, a good example of that, right? You said you were going to hire me. I turned down this job offer over here, and then you don't hire me. You would have to pay me what I would have got from the other job opportunity, right? So it just replaces the value of the lost opportunity. Now, again, there's expectations, the way these compensations are is what are the incentives against breach, right? And again, there's no perfect answer, right? What do we do? Remember, under tort law, what happened was that if you had strict liability, then what happened was the potential victim didn't have incentives to take efficient precaution. And if you had no liability, the potential injurer didn't have incentives to take precaution. And then what we ended up with, a negligence rule, right? A negligence rule that got both parties to undertake precaution. The problem here is very similar. That is, I've got I have an economic incentive that's built in when I get paid damages, right? And so how do you make it so that you get efficient precaution? Well, it's hard to do. And again, it's not a matter of we know what the right answer is. It's a matter of we know how to think about it. And there might be situations where it's clear that expectation damages are the right way to do it, right? And there might be situations where it's clear that reliance damages are the way to do it. Or it might be that, again, opportunity costs would be the way to do it. But if we look at it, what would we expect? Generally, if we would expect that in terms of the size of the damage, generally, they would fall in the order of this. Expectation damages, right? They would be the most. Then you would have reliance damages, right? Because this puts you at a higher level than just, because you would have gotten some profit, right? You wouldn't have gotten into the bargain if you didn't think there was going to be profit made. So we would expect generally expectation damages to be greater than whatever your reliance damages are. And then opportunity cost is probably less than the reliance damages. And again, if you knew what the damages were going to be, then you would undertake different types of precaution. And so how you want to structure the damages would depend on the situation that the contract would have.
So with that ordering, seems to me like take the housing example, reliance damages, right? That would cover closing costs, inspection fees, stuff like that. But
yes.
Opportunity costs, wouldn't that cover like the whole price of another house?
Well, no. It would be what did you give? They're not going to make you pay for the new house. They're going to make you pay for what the gain. Yeah, right. You're exactly right. I'm sort of putting this.
Like I think a concert.
That's a good question. They're not going to make you if I decide not to sell you your house, I'm not going to have to pay for the other house. I'm going to pay you the difference in what the value to you was between my house and the other house.
Okay, so in a band situation, it says your band, and then the opportunity was like Britney Spears.
That's correct. That's correct. That's correct. And of course, what's a big problem? Any of these things where you're awarding damages, whether it's tort law or whether it's contract law, how the heck do you measure it, right? I mean, conceptually, we can think of, oh yeah, okay, what was your opportunity cost? It's the difference between the value of the value to you of my house and the value to you of the other house, right? Well, okay. What could you have done, and what was the value that you would have got out of that, right? What's the value that could have got out of the other thing? How do you go about measuring that, right? That's again, any of these damage situations, whether it's tort or whether it's contract law, you have to think about that. In fact, the simplest way to do it is restitution damages, or it's not really damages. The simplest way to do it is just simply restitution. And what is restitution? Restitution says that I'm just going to return what the promisee gave you, right? Just return what the promisee gave you. So that if the premisee gave you $10,000 to do this thing, then what do you got to do? You just got to give them their $10,000 back. Okay? That, in general, we might expect to be less than reliance, unless there wasn't any reliance costs, right? If you didn't rely on anything, and so the simplest way to do it is restitution. I don't have to measure what these costs are. Just give me the money back. I don't have to go into, well, here's how much, we don't have to go into court and have to say, oh, well, gee, here's how much I paid for the arena and et cetera. Here's how much I would have, expected to get from the concert going on. Here's the other band that I could have had if I had, I would have made this much if I'd have had the other band, et cetera. So you don't have to measure all that. It's very, it's simple. Now, that's its advantage. But because it solves this, again, the problem with determining value, right? The same thing with that we had in tort law. How do I know how much these? How do I measure damages? In particular, what do you do if you have an item that's not priced in the market? Okay, so if we're doing restitution, what if it's not priced in the market? Sort of think about this. Remember, or where your value. I mean, if it's something that there's not a price, right? Your leg, okay, which was happening when we talked about tort law, right? Or it might be that you value it differently than what the market price was, okay? Or you value differently than the market price. Again, these things keep showing up over and over again, right? Because what was the problem with eminent domain? Under eminent domain, what it says is that we could take your property, right, for a public purpose, and we have to pay you what? Market value, right? What happens if the market value is much less than the value to you, right? There's a house that all your kids were born there, and you value it at $500,000, and market value is only $300,000. That's a problem, right? That we talked about in eminent domain. You got a similar thing here. For example, what if you were gonna sell me a Paul McCartney ticket, right? So you get on. I don't know. There must be some. Where can you buy things? Tickets for concerts online or something. Ticketmaster. Yeah. Okay. Very good. Okay. So Ticketmaster. Suppose that I give Ticketmaster $100 and they say they're going to deliver a Paul McCartney ticket, but then it turns out that they don't. Right? Something comes up and they didn't have enough Paul McCartney tickets to sell to you, and so it fails to deliver. The Ticketmaster fails to deliver you the Paul McCartney ticket. And no Paul McCartney tickets are now available. Okay? So you thought you were getting it from Ticketmaster, but now the McCartney concert's sold out and there's no ticket available. They can't give you your the value to you back, because the value to you was, let's say the value to you is $500, right? Because there's the value to you is going to be at least as large as the ticket, right? But you could have had some consumer surplus, right? So how do you handle, another way to put it, how do you handle consumer surplus? So we just said there was, a $100 Paul McCartney ticket, right? You didn't deliver, right? There's no more tickets available, and I value at $500. Right? So again, just problems in measuring damages, right? There's all sorts of different problems you can see that when you go to measure damages, how do I really know what the profit you were going to make when I'm doing expectation damages? How do I really know what your opportunity costs were? And so there's, again, just like you saw in tort law, there's going to be difficulties. Now, it may be that in certain instances you're pretty sure, or at least you got a general idea, and you may want to have. There might be situations where the easiest thing to do is just, hey, give you your money back, right? Just restitution. But that didn't get you back to where you were in the sense that, oh, gee, I thought I had this Paul McCartney ticket, now I can't get one, and now it's more like if there's this, again, like eminent domain, what do you do about if the subjective value of the thing is different than what the market value is? All right, so a third way of doing this would be to require you to do specific performance. The court could require specific performance. Right? So you can have it written into the contract. Sometimes it'll be there, but there's lots of different stuff that you wouldn't have thought about. It's expensive to write contracts, to spend all the time trying to think through. The court could say you got to pay damages. What kind of damages are they going to do? And what do you do about a third situation where they might say, hey, you don't have to pay, you have to deliver, right? The court could require specific performance. Say, no, you have to fulfill this. Let's say there's some unique good that you've decided that maybe you could have sold to somebody else and you don't deliver it, right? And so you've got this piece of art and you just decide, no, I've decided I'm not going to sell it. The court could say, no, you have to, rather than award damages, it could say you have to deliver. What's the advantage of that is the court doesn't have to, normally it has some sort of, especially, when would this happen? Especially if you have some sort of unique good and there's basically a clear market value. The advantage of specific performance is the court doesn't have to figure out the damages, right? The court doesn't have to figure out the damages to the promisee. Right? Rather than just trying to figure out, are we going to do expectation damages? Are we going to do restitution? What are we going to do? We're just going to say, hey, you just have to go ahead and performance. Again, there's going to be some cases where it's clear that one option is better than the other, but there's no perfect way to determine. All we're trying to do here is to get you to understand here's what the courts could be doing, and to understand, okay, do I have a particular situation where it should go, it might be clear it should go one way or the other. Now, let's look a little bit more about when the court might specify what the remedy, where the contract might specify the remedy. Okay? Again, we're just going to go into things with some additional observations about stuff. Okay? So what happens if the contract specifies what the remedy is? The court might not enforce if it's not reasonable, right? That is, remember when we were talking about when the court might not enforce the whole contract, right? One of the things that we said that you know, if there was the incompetence of the person to write the contract, right? You don't have contracts with minors be enforceable, etc. Rather than set aside the whole contract, when might the court set aside the specification of what the remedy says? The court just might say, similarly, the court might say that it might want to do it if it sets aside, if it's not reasonable, right? And I'm going to say, as with the whole contract being enforceable, it might decide it's not reasonable. So, okay, this is not the. This is the, you know, you guys agreed to this, but it's really not reasonable, right? So, like we said before, the court might throw out the whole contract if they think it's not reasonable, but the court might throw out this specific remedy. There's a thing. It's called a penalty clause that you might put in a contract. The contract might have a penalty clause. And so you've written into the contract what the penalty, what the damages are going to be, and it's called a penalty clause if it exceeds the expectation damages. Right? So the courts may, the court's trying to decide if this thing's reasonable, right? If what you wrote into the contract's reasonable. And it might say, well, what happens if you've written into the contract that the penalty from the promisor is going to be larger than what the expectation damages would be, so that why would you put that in there? Why would you allow that to be enforced? Why would you make it so that the promisee is going to get more than what their expectation damages would be? And so in a sense, they'd be better off with the breach happening. Well, the court might enforce such a thing is if the reason I put it in, okay, why would I enforce the penalty clause? That is, why would I enforce this specific remedy? And one reason is the promisor is basically giving an insurance. It's like an insurance policy in a sense, giving insurance to the promisee. Right? And why would they be doing that? To get them to agree to the bargain. There might be reasons that you put in a specific remedy which is relatively high, because I'm pretty sure as let's say I'm the promisor, right? I'm really sure that I'm going to be able to deliver this to you. right? But you're not so sure that I'm going to deliver it to you. So what I might do is I might say, hey, guess what? I will put in a penalty clause in the sense that I will put in what the specific remedy is going to be, and it's going to be big, okay? Why? Because I'm like sort of your insurance policy on the thing not going through, right? I'm saying, hey, I'm not only going to perform, but I'm going to be your insurance agent for this, or I'm not your insurance agent. I'm going to insure you against the thing falling apart, okay? Because I know that I really know that I'm going to be able to do it. Another reason is, so I've gotten you to go ahead and agree here because I'm way more certain than you about whether I can fulfill the contract or not. Another reason might be if it's a communication device, right? It communicates to the promisee how confident the promisor is that they can fulfill the contract. Again, it's just sort of thinking about the logic. I'm trying to get you, I'm trying to get you to bargain with me. I could either say, hey, I'm willing to insure you against this, and then I'm going to pay you more than what your expectation damages are, or I'm communicating to you that, hey, I'm pretty sure that I'm going to be. In fact, I'm really sure that I'm going to be able to deliver to you. If you sort of think about it, you could do the same thing by having a bonus that the promisor gets if they deliver early or if they deliver in a better fashion, okay? So you could write it as a bonus, similarly, a bonus to the promisor can function the same way. Because they give up the bonus if they fail, right? So this might be something where this might happen is you say, okay, you're going to deliver this car by Friday, and you'll get a bonus if you deliver it by Monday, right? And so if you don't deliver it by Monday, in a sense, it's a penalty because you gave up the bonus, right? If you don't deliver it by Monday, you gave up the bonus. So then you can sort of think of that as being a penalty clause similarly. But again, you can, again, I know that I'm going to get an extra $100 or something if I get it to you early. You know that I think I can get it to you early because I'm willing to give up this $100 if I don't get it there on time. So again, it's a communication here. All right, so let's do a little more discussion here about what about remedies, because as I said, when we're looking at tort law, we want to have what? Well, in tort law, we want, we've done this a million times, right? Under tort law, what do I want? I want efficient precaution. Under tort, I want efficient precaution by both the potential victim and the potential injurer. Right? And they were, we had the simple algebra where we had Wx, where x is the amount of precaution, W is the marginal cost of the precaution. We assume it's a constant. plus we have P of x times A, where when you increase x, the probability goes down, right? The probability of the accident goes down, and A was the cost of the accident. And so what are you trying to do? You'll optimize that where W is equal to P prime of x, right? Times A, right? The reduction in the expected loss is going to just be equal to the marginal cost of the additional precautions. So you got a similar idea here. That is, I want to have efficiencies, and we also noted that when we were looking at if the cost of, if you were sort of thinking about it, if the cost of performing, when we talked about this earlier, right? If the cost of performing is greater than the benefit from the performance happening, then we ought to allow breach, right? If it's going to be efficient, I wouldn't want you to, you know, if it turns out that there was something that happened, some accident that happened, and the cost of you performing the thing was $300, and the perfect expectation to me was $200. Well, we want you to breach. So for an efficient breach, if for an efficient breach, if the promisor the promisor should be able to breach if the cost of performing is greater than the damages, right? Is greater than the expectation damages, or then it would be efficient for you to breach the contract. Now, what could happen is that if we were to have low transactions costs, like you have some unfortunate, you know, you have some contingency that happened, it might be that the parties could renegotiate, right? Because if there's going to be some surplus from the breach, right? There's going to be a surplus from the breach. Right? The cost of performing is bigger than the expectation damages. It might be that the parties renegotiate the contract, right? If you have low transactions costs. Right? Sort of the Coasian idea that if there are low transactions costs, what will happen? You guys will bargain over who gets the property right, okay? So if there's a $500 advantage in breaching the contract, then what might happen is we might renegotiate so that you're going to get some of the advantage and I'll get some of the advantage, and I won't end up breaching. We'll have a new contract, all right? So that's something to think about. All right, so what we're going to do is we'll look at unfortunate foreseen events and fortunate foreseen events, and then the paradox of compensation. What do we do if there was something that made it better for the promisor that was undiscovered, or something that made it, you know, it was an unfortunate event, you know, COVID-19 hits, or then what's the paradox of compensation going to be? It's going to be the same thing that we talked about under tort law. That is, if the victim, you know, is going to be compensated, then they're not going to take sufficient precaution. That's the paradox of compensation, right? Is that the parties aren't going to have a way to have efficient precaution if you compensate. And so, can you put something together that sort of looks like negligence? And we'll talk about that. All right. So what we're going to cover for the midterm is what we cover on Friday and Monday. Like I said, we're not going to go through all of Chapter 9. We're going to just do whatever we get done by Monday.